In the Qatar case, the court issued a provisional order where harm to approximately 150 students was an issue. In Gaza, 625,000 school children have not attended school for 3 months, with the United Nations Security Council expressing deep concern, I quote, that the disruption of access to education has a dramatic impact on children and that conflict has lifelong effects on their physical and mental health. Almost 90,000 Palestinian university students cannot attend at university in Gaza. Over 60% of schools, almost all universities, and countless bookshops and libraries have been damaged or destroyed, and hundreds of teachers and academics have been killed, including deans of universities and leading Palestinian scholars, obliterating the very prospects for the future education of Gaza's children and young people. Notably, the court has found provisional measures to be justified in all 3 cases where they were previously sought in relation to violations of the Genocide Convention. It did so in Bosnia and Serbia in 1993, finding on the basis of evidence that was certainly no more compelling than that presently before the court, that it was sufficient to determine that there was, and I quote, a grave risk of acts of genocide being committed. The court found provisional measures to be justified in the Gambia-Myanmar case on the basis of a risk of irreparable prejudice to the Rohingya, subject to, quote, mass killings as well as beatings, the destruction of villages and homes, denial of access to food, shelter, and other essentials of life. More recently, in indicating provisional measures in Ukraine-Russia, the court considered that Russia's military activities had, quote, resulted in numerous civilian deaths and injuries and caused significant material damage, including the destruction of buildings and infrastructure, end quote, giving rise to a risk of irreparable prejudice. The court had regard to the fact that, quote, attacks are ongoing and are creating increasingly difficult living conditions for the civilian population, end quote, which it considered to be extremely vulnerable. The court also considered the fact that, I quote again, many persons have no access to the most basic foodstuffs, potable water, electricity, essential medicines or heating, and that many were attempting to flee under extremely insecure conditions. This is occurring in Gaza on a much more intensive scale to a besieged, trapped, terrified population that has nowhere safe to go. Lest the contrary be suggested, it is clear from Ukraine-Russia that the fact that the urgent risk of irreparable harm arises in a situation of armed conflict does not undermine, much less preclude, a request for provisional measures. That's also clear from the court's other judgments. So in the case of armed activities on the territory of the Congo, for example, the court ordered provisional measures based on its finding that, quote, persons, assets and resources present on the territory of the Congo, particularly in the area of conflict, remain extremely vulnerable, and that there was a serious risk that rights at issue in the case may suffer irreparable prejudice, end quote. Similarly, in Costa Rica, Nicaragua, the court indicated provisional measures in part on the basis that the presence of troops in the disputed territory gave rise, I quote, to a real and present risk of incidents liable to cause irremediable harm in the form of bodily injury or death, end quote. In relation to the Genocide Convention in particular, the court recalled in Gambia, Myanmar, that, quote, states parties expressly confirmed their willingness to consider genocide as a crime under international law, which they must prevent and punish independently of the context of peace or of war in which it takes place, end quote. More recently, in the case of Guyana, Venezuela, the court considered that the serious risk of Venezuela, quote, acquiring and exercising control and administration of the territory in dispute, end quote, gave rise to a risk of irreparable prejudice to the rights asserted in the case. Similar factors are an issue here, having regard to the territorial ambitions and settlement plans for Gaza being raised by members of the Israeli government, and the relationship of those factors to the very survival of Palestinians in Gaza as such. Similarly, any scaling up by Israel of access of humanitarian relief to Gaza in response to these proceedings or otherwise would be no answer to South Africa's request for provisional measures. In the case of Iran, United States, the court found a risk of irreparable harm from the exposure of individuals to danger to health and life caused by restrictions placed on medicines and medical devices, foodstuffs and other goods required for humanitarian needs. That was notwithstanding the assurances offered by the United States for it to expedite the consideration of humanitarian issues, and notwithstanding the fact that essentials were in any event exempt from the United States sanctions. The court considered that the assurances were, I quote, not adequate to address fully the humanitarian and safety concerns raised, and that there remained a risk that measures adopted by the United States may entail irreparable consequences. In Armenia, Azerbaijan, unilateral undertakings to alleviate restrictions alongside the full resumption of humanitarian and commercial deliveries did not defeat requests for the indication of provisional measures. The court was clear that while contributing, quote, towards mitigating the imminent risk of irreparable prejudice resulting from the military operation, those developments did not remove the risk entirely. Indeed, in Georgia, Russia, the court made clear that it considers a serious risk to subsist where, quote, the situation is unstable and could rapidly change. The court considered, quote, given the ongoing tension and the absence of an overall settlement to the conflict in this region, populations also remain vulnerable, end quote. Israel continues to deny that it is responsible for the humanitarian crisis it has created, even as Gaza starves. The aid it has belatedly begun to allow in is wholly inadequate and does not come anywhere close to the average 500 trucks being permitted daily before October 2023, even under the blockade. Any unilateral undertakings Israel might seek to give about future aid would not remove the risk of irreparable prejudice, not least considering Israel's past and current conduct towards the Palestinian people, including the 16 years of brutal siege on Gaza. In any event, as the United Nations Secretary-General has made absolutely clear, it is a mistake to measure, quote, the effectiveness of the humanitarian operation in Gaza based on the number of trucks allowed in. As he stressed, I quote, the real problem is that the way Israel is conducting this offensive means that the conditions for the effective delivery of humanitarian aid no longer exist. That would require security, staff who can work in safety, logistical capacity, and the resumption of commercial activity. It requires electricity and steady communications. All of these remain absent, end quote. Indeed, only shortly after Israel opened the Kerem Shalom crossing to goods in late December 2023, it was struck in a drone attack, killing 5 Palestinians and leading to another temporary closure. Nowhere and nobody is safe. As the United Nations Secretary-General and all its chiefs have made clear, without a halt to Israel's military operations, crossings, aid convoys and humanitarian workers like everyone and everything else in Gaza, remain at imminent risk of further irreparable prejudice. An unprecedented 148 United Nations staff have been killed to date. Without a halt to Israel's military activity in Gaza, there will be no end to the extreme situation facing Palestinian civilians. Madam President, members of the Court, if the indication of provisional measures was justified on the facts in those cases I have cited, how could it not be here, in a situation of much greater severity, where the imminent risk of irreparable harm is so much greater? How could they not be justified in a situation that humanitarian veterans from crises spanning as far back as the killing fields of Cambodia, people who, in the words of the United Nations Secretary-General, have seen everything, if they say it is so utterly unprecedented that they are out of words to describe it? It would be a complete departure from the long and established line of jurisprudence that this Court has firmly established and recently reconfirmed for the Court not to order provisional measures in this case. The imminent risk of death, harm and destruction that Palestinians in Gaza face today and that they risk every day during the pendency of these proceedings, on any view justifies, indeed compels, the indication of provisional measures. Some might say that the very reputation of international law, its ability and willingness to bind and to protect all peoples equally, hangs in the balance. But the Genocide Convention is about much more than legal precedent. It is also fundamentally about the confirmation and endorsement of elementary principles of morality. The Court recalled the 1946 General Assembly resolution on the crime of genocide, which made clear that, I quote, "Genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses to humanity in the form of cultural and other contributions represented by these human groups, and is contrary to moral law and to the spirit and aims of the United Nations." End quote. Notwithstanding the Genocide Convention's recognition of the need to rid the world of the odious scourge of genocide, the international community has repeatedly failed. It failed the people of Rwanda. It had failed the Bosnian people and the Rohingya, prompting this Court to take action. It failed again by ignoring the early warnings of the grave risk of genocide to the Palestinian people, sounded by international experts since 19th of October of last year. The international community continues to fail the Palestinian people, despite the overt, dehumanizing, genocidal rhetoric by Israeli governmental and military officials, matched by the Israeli army's actions on the ground. Despite the horror of the genocide against the Palestinian people being live-streamed from Gaza to our mobile phones, computers and television screens, the first genocide in history where its victims are broadcasting their own destruction in real time in the desperate, so far vain hope that the world might do something. Gaza represents nothing short of a moral failure, as described by the usually circumspect International Committee of the Red Cross. As underscored by United Nations chiefs, that failure has, I quote, repercussions not just for the people of Gaza, but for the generations to come, who will never forget these over 90 days of hell and assaults on the most basic precepts of humanity. As stated by a United Nations spokesperson in Gaza last week, at the site of a hospital clearly marked with the symbol of the Red Crescent, where 5 Palestinians, including a 5-day-old baby, had just been killed. The world should be absolutely horrified. The world should be absolutely outraged. There is no safe space in Gaza, and the world should be ashamed.